Hello and welcome students. Today we will discuss about kinds of state. So we can categorize states into three parts. First has the sovereign states, and second category of not fully sovereign states, and thirdly the non-typical states. So most of the categories may interfere, like they are interchangeable. This non-typical states can be again a sovereign states, and a sovereign states can be non-typical states. Let us discuss it in detail. It's better. So first we will discuss about sovereign states in this lecture. Okay, Max Huber stated that sovereignty in the relations between states signifies independence. That is what sovereignty means. The another sense of sovereignty is the independence. Independence in regard to a portion of the globe is a right to exercise therein to the exclusion of any other state. So he has stated that sovereignty lies within the jurisdiction of an independent state within its limits, territorial limits. He has stated so, with the exclusion of any other powers. Any other state or nation cannot interfere within the sovereignty, the independence, the right of independence is not interfered by any other powers. Thus, the essential elements of sovereignty are: it is exercised within territorial limits. Sovereignty constituted by the independence of the state power from any other power, that is, an authority over which there is no other authority. So, that was the element of sovereignty. Again, a sovereign state is independent in two ways. First, independence in its internal affairs, and second, independence in external, or that is foreign affairs. There is a considerable difference between these two aspects of state sovereignty, that is the internal and the external affairs. So in terms of its application, let us discuss it as follows. So we will discuss first the independence of internal affairs. In consequence of its internal independence, a territorial supremacy, a state can adopt any constitution it likes, arrange its administration in any way it thinks fit, enact such laws as it pleases, organize its forces on land and sea, build and pull down fortresses, adopt any commercial policy it likes, and so on. Interference of one state in the affairs of another state in the internal matters is unjustified. A sovereign state is not free to do even in its internal affairs, which are detrimental to the freedom and independence of other states. So, even though they are independent in their internal affairs, it must not harm. The impact must not be that it is interfering with the other foreign states. A sovereign state under its constitution may create rights, status and competence which, howsoever wide, operates its subjects to the limits of international law, and is required to enact the appropriate laws to fulfill its international obligations. Anyways, though they are independent sovereign in their internal affairs, they have to follow the international law. A state has a duty to protect human rights and fundamental freedoms of its citizens, demonstrating a duty to protect people's rights. So, let's understand the independence of a state in terms of external affairs. A state is independent to exercise its external functions, that is, external affairs. Consequently, a state is free to frame its foreign policy. It can establish relations with other states, and it may decide itself on all foreign issues affecting it. No other state can prescribe the rules of conduct which a sovereign state should follow in international affairs. If the former does it, it would be regarded interference in the external affairs of the latter, which again is not justiciable. So, earlier in independence of internal affairs, we stated that the independence, the sovereignty must not disturb the other state. In the same way, the independence of external affairs of a state should not disturb, it should not interfere in other states functioning, you can say. It is not justified. In international law, where all states are equal and sovereign, the sovereignty no longer conveys the idea of supremacy of a particular single state due to drastic change in the meaning of the term sovereignty and rapid developments in its law. So, earlier there was a meaning for sovereignty, but since international law has developed rapidly, it has gained the power to control these sovereign states. States themselves have placed limitations on their supreme and absolute powers by giving their consent to the international laws. So, we have some doctrines in terms of sovereign states. First, the principle of equality of states. Even though they are sovereign, there are several sovereign states, but the principle of international law is equality of states. This principle has been recognized under Article 2, Para 1 of the Charter of United Nations, which says that the organization is based on the principle of sovereign equality of all its members. Again, under the Draft Declaration on Rights and Duties of States, Article 5 provides that every state has the right to equality in law with every state. So, this part states about the right of equality of every state. Again, within the General Assembly of United Nations, the doctrine of equality of states is maintained by the rule of one state, one vote, irrespective of realities of power. That is the realities of power we can understand. The powerful countries like America, maybe the not so much powerful country like Pakistan, Bangladesh, Sri Lanka, but there is a one vote, one state. Further, no state can claim jurisdiction over other states, and as a rule, courts of one state do not question the validity or legality of the official acts of another sovereign state or the official acts of another state. In particular, sovereign equality includes the following elements. First, states are juridically equal, that is, the legal system, administrative system is equal to all. The international administrative or legal system is equal to all. B. Each state enjoys the rights inherent in full sovereignty. So, there is no discrimination in enjoying their equal rights. Each state has the duty to respect the personality of other state. The territorial integrity and political independence of the states are inviolable. So, the political and the territorial integrity should not be disturbed, should not be violated by other states. Each state has the right freely to choose and develop its political, social, economic, and internal systems. There may be competition in terms of economic systems, internal systems, political systems. Every country looks for developing itself in all these terms, but even then, it has a right freely to choose and develop its political, social, economic, and internal systems of its own for its own development. Again, each state has a duty to comply fully and in good faith with its international obligations and to live in peace with other states. So, the doctrines has sovereign states. The another principle of the sovereign state doctrine is principle of good neighborliness. Good neighborliness. Preamble of the Charter of the United Nations lays down that states shall live together in peace with one another as good neighbors. So, this was under the Charter of United Nations. Again, under Article 74 of United Nations Charter states that members of United Nations also agree that their policy in respect of the non-self-governing territories must be based on the general principle of good neighborliness. So again, they have mentioned about good neighborliness. A state is also under a duty to prevent its territory from being a source of economic injury to neighboring territory. A state is also responsible if it causes damage to the environment of other states or of areas beyond the limits of national jurisdiction. So, this was regarding the sovereign states. Chalo, thank you.